Joining us now in the studio, our good friend Aaron Rice. He is the director of the Mississippi Justice Institute. Morning, Aaron.
Morning, Gerard. Afternoon. How you doing?
Barely into it. So, you always got some interesting cases that you get involved in. That's what you do down there at the Justice Institute. We appreciate that. So, the one we asked you to come in and talk to us about today involves Mississippi's Certificate of Need laws. In case you got related to that, we call it CON for short. The CON laws, that's all caps. You know, wasn't too long ago, we had a little panel discussion out in Rankin County. You remember that, about this and our efforts. This is something, full disclosure, that I have been a proponent of, and that is to reform, if not totally repeal, our Certificate of Need laws. I think that's just anti-free markets in my view, and I think it's gross overreach. And maybe you could argue there was a time when there was some validity and some value in these laws, but I don't think that's the case anymore. So if you don't mind, Aaron, start by explaining exactly what Certificate of Need laws are.
Yeah, so I mean, a Certificate of Need law is basically says that if you're an entrepreneur trying to get into the healthcare space, you have to prove that you're needed before you can do that. And I mean, this is not anything to do with whether you're safe or sanitary or a good quality healthcare provider, just whether you're needed. And con laws are sometimes called competitors' vetoes because the way the government evaluates whether there's a need is by asking your competitors whether they think there's a need in the market. And in fact, your competitors are invited to show up at the applicant's hearing and engage in what is essentially a full-blown trial where they can testify that the existing businesses are perfectly capable of serving all the existing demand, and in fact, no new company is needed. But you know, of course, there's an inherent conflict of interest there. I mean, you can see how an incumbent business has an incentive to say that there isn't any demand so that they can keep that demand for themselves. And it would be difficult for any entrepreneur to prove that they're needed. I mean, the way you do that is open up your doors and try. But a lot of times entrepreneurs aren't even allowed to try. And you know, that's what makes America great is that we give people the opportunity to invest their own time and their own resources and bravely experiment and see if they can do it better than their competitors. But in this space, we do not allow people to do that. It really is a competitor's veto. It's insane that we still have this on the books here in Mississippi. We're one of 35 states that still does. It used to be 49. It's down to 35. We are litigating this in the home health space where it's even more absurd. And to make it even worse, in our client's case, in this home health sector, there's not just a Certificate of Need application process, which is very burdensome. He can't even apply for a Certificate of Need because there has been a total ban in Mississippi for 40 years for anybody to get into the home health space. And so our client wants to do this. You know, he saw during COVID that a lot of people were trying to stay out of nursing homes. They were prone to these outbreaks. And that's what home health really does best, is help people stay out of the nursing home, provide care in the home. And so he tried to respond to this, you know, explosion of need in the state. And he ran headlong into a Mississippi law that says, hey, Butch, if you do that, we will fine you $1,000 per day for trying to help your community. That's what we're up against.
And as I recall, a little background, this originated in New York. It seems like in the 60s.
That's right. Yeah, that's right. It started in the 60s with some states, and then in the 70s, the federal government picked it up.
That's right.
Yeah.
But then the federal government, as I recall, got out and said, okay, states, do whatever you want.
Exactly.
We're one of the remaining 35, still have this on the book.
Exactly. And that's what's so hilarious about it is that the federal government, they got into the game because the hospitals started lobbying for these because they realized it would protect their bottom line. And the federal government was paying a lot for Medicare and Medicaid, and they thought, hey, if this is a way to control costs, let's require all the states to do it. So they did require the states to do it if they wanted to keep their health care subsidies. 49 states did. Louisiana didn't. You know, Louisiana likes to kick the system a lot of times, but 49 states did. Very quickly, that started in the 70s. By the 80s, the federal government realized it was having the exact opposite of the intended effect. It was driving prices up. It was driving quality down. It was driving access down. And the feds admitted it. They said, whoops, this was a mistake.
Yeah.
Let's get out of this. And so they repealed that law that required the states to do it. But the problem is, once you give people a shield from competition, monopolies like their monopoly.
Sure.
And they will lobby and spend a lot of money and give politicians a lot of money to keep that shield in place.
Well, yeah, I mean, it's crazy as it may sound. The idea was if we limit supply, we'll keep costs down. I don't know where the hell they got that idea from. But the other thing is we'll protect those that want to enter various aspects of the healthcare industry from doing something stupid and going out of business. They literally thought that.
They did. They thought that this destructive competition might, harm hospitals. And they also thought that hospitals were spending too much money on expensive equipment and then were overcharging their patients to recoup that cost. Which, again, if basic economics will just tell you that that's not what's going to happen. I mean, in a competitive market, which is what we do not have right now, entrepreneurs and healthcare facilities, need to stay on top of their game if they want to stay in business. And they have every incentive to lower their prices and innovate and offer quality services because they need to attract patients. But in a non-competitive environment like we have right now, you don't have to lift a finger. You don't have to do anything, and patients will still come to you because you're the only game in
limited.
town.
Yeah, the market, of course, is the ultimate test here. So before we get to the case, let's talk about just the examples and then the process. An example of where a party may have to seek a certificate of need would be a hospital that wants to add beds, add wing, buy particular pieces of equipment that are defined in the like an MRI machine is the one that CT scanner comes to mind, right? Setting up a new healthcare facility as an example,
or even moving or expanding or changing ownership of an existing facility.
Okay, gotcha. Didn't know that.
It's so many things, and basically what you have is that there's a few things that are exempted under the con law. So like private practice physician clinics, this is like your primary care doctor is not subject to this. Veterans homes aren't, abortion clinics aren't, state-owned facilities aren't, and a few others, but basically everything else is. So all the specialty care you get in the state, the home health care you get, the hospital care, virtually all of the care that's available in Mississippi, or most of the care that's available in Mississippi, has to go through this competitor's veto process where they have to prove to the government that this is needed. And it's not even really the government, because the government turns to your competitors and asks them what they think. And they can literally take you into court and fight you, in litigation, arguing that there's not enough need for this, instead of just, letting competition happen. And that's what really drives innovation. And like we've already talked about, that drives down prices. That increases, access and increases quality. That's what we need to be doing.
UMC?
What about it? I mean, I'm sure that
it's a rhetorical question.
Yeah. I'm sure that they, like a lot of providers, and you can understand where they're coming from.
I'm asking, do they not have a special exemption here, a carve out?
Oh, no, not to my knowledge.
Okay.
Yeah. And so, but they are an incumbent healthcare provider, and I think that, like I said, I think it's understandable that anybody who had this protection would like to keep it.
Yeah, and listen, UMC is a wonderful place. I have many friends that work there. I'm not being critical of them. I'm just, for some reason, I thought there was some sort of special exemption.
If there is, I'm not aware of it. But if there is, I'm not aware of it. But I'll tell you that our con statute is just so lengthy and
convoluted
dense
too.
That I, who knows, it may be in there and I've missed it.
So it starts with an application, right, to the Board of Health.
That's right.
And then it goes from there.
That's right. It goes from there, and it's a lengthy application. You have to, again, try to prove you're needed, which, how do you do that?
You'd have to have lawyers to help you.
You do, and consultants. You need to hire consultants. Yeah. It's a lengthy application. You got to pay a fee. And then, listen, once you give it to the Department of Health, they are required, under the law, to notify your competitors and invite them to come in and fight against you. And, literally, they have the right to hire attorneys, to testify, to cross-examine you, to bring in experts, to write motions, to dismiss your application, again, engage in full-blown litigation. And if they lose there, they can appeal it into an actual court of law, and it can go all the way up to the Mississippi Supreme Court. So you can be waiting years, paying lawyers, paying consultants, paying expert witnesses.
Drill a dry hole.
Yeah, and then you get to the end of that process, you might have spent hundreds of thousands of dollars, and, arbitrarily you're told, nope, you can't do this. Not because you're not a good healthcare provider, not because you're unsafe or anything like that. You got to be clear here. we have wholly separate areas of the law that are licensure requirements that already address making sure that you're a good provider.
Yeah.
So that's already there.
Yeah.
This has nothing to do with that.
A broad regulatory framework exists already on that. When we come back, we'll talk about the suit specifically. But before we go, I just want to encourage those listening or watching, think about your own business and apply this scenario. You want to expand, you want to grow, you want to open up a new location, whatever the case may be, and you got to get permission from the people you're trying to out-compete with in the market. That's what this is.
It's exactly what it is.
We'll be back with Aaron Rice from the Mississippi Justice Institute after this break. Mississippi, a couple of texts here related to our discussion. Aaron, Darren in Jackson reports that Senator Hob Bryan, Democrat in the Mississippi Senate, said on the Gallo show this morning that if we did away with the con laws, it would be a complete disaster for the people of Mississippi. Not surprised there, honestly. And then this listener, Jack in Jacktown, wanted to know about states with similar legislation. I think we reported in the last segment 35?
Yeah, 35 states still have this. It used to be 49. It's gone down to 35. And in the states that have repealed it, there's no evidence of any ill effects in the healthcare system there. In fact, I mean, those states are doing better. And so, that's one thing that we haven't talked about is that we've seen this play out for 40 years now. There's been a lot of research into the subject and government studies into the subject. And it really is universal out there. You mentioned a legislator saying it would be, the sky would fall if we got rid of this. Just like you, I'm not surprised by that because, the industry insiders spend a lot of time and a lot of money trying to convince our lawmakers of that. But if you get outside of their world, I mean, the people who benefit from this and what they have to say about it, it really is universal out there. Everybody who is a neutral, party who's not vested in this and looks at it, the Federal Trade Commission, the Department of Justice, academic researchers, government researchers, they all universally say certificate of need programs do not work.
And I can tell you, and I know you've been working on this in your organization. I have, just as a private citizen, encourage my lawmakers and my contacts in the legislature to get something done here, and was honored to participate on a panel discussion crusading for repeal.
Yep.
But it never makes it out of committee.
Yeah. Yeah. And, the order that we're here to talk about in our case talks about that, talks about rent seeking and how it works and how, it's really money and votes for politicians in exchange for a monopoly. And so, even in the court case that we're dealing with, that's kind of laid bare some of how that works.
Yeah. All right, so tell us about the case specifically.
Yeah. So, we just got an order in the case from Judge Carlton Reeves. We're very excited about it. He denied the government's motions to dismiss our case right now. And so, as small of a victory as that may sound, we won the right to have our day in court is what we really won. But it's a big victory because in a case like this, when you're challenging an economic regulation of the state, the court gives a lot of deference to the government. It's a very low bar they have to clear. Basically, as opposed to some fundamental right that the court might look at where they say, the government has to have a compelling reason to have this regulation and it has to use the least restrictive means to accomplish their goals. Here it's like, if there's even a theoretical conceivable reason that the government might have to have this law, then it's constitutional. And, the judge can just, even if he wants to, invent potential reasons that the law should exist, even if they're not the real reasons or even if they don't work, even if that isn't what the law does. And so it's very hard to even, get your day in court on a case like this, and that's what we got. The good news is that cases that tend to get past the motion to dismiss usually do very well, because if the government can't get it dismissed at this stage, then that just goes to show how absurd the law is. And so we're representing Butch Slaughter. He's a physical therapist here in Jackson. He built a physical therapy clinic back in the 80s in South Jackson. He wants to get into the home health agency industry because, again, like I said, COVID has increased the demand of that. He has seen a need for that. He has seen that the existing monopoly home health agencies are not doing a good job. He's seen that over the course of his career. But, to do that, theoretically, he would have to get a certificate of need to get into the HHA space. And, that would be very burdensome. But like I said earlier, we've had a 40-year ban on even issuing certificate of needs to new home health agencies. And so he can't even apply. It is literally completely illegal for him to do this. He's trying to help his community. He sees a need out there, and he cannot address it. He can't help his community. So we filed a lawsuit for him. We are arguing that this violates the Constitution because the government is taking away his dream, his right to work, depriving his patients of choice and access to health care, and the government is acting arbitrarily, which is unconstitutional because they're only doing this to protect incumbent health care providers, and they're not accomplishing any legitimate government interest. They say, as you and I talked about, basic economics will tell you this isn't correct, but they say this increases access to health care somehow. They say this increases the quality of health care somehow. They say this drives down the prices of health care somehow. And in our lawsuit, we are seeking to prove that none of that is true, which I've already referenced to you. There's a lot of overwhelming evidence to show that. And we're trying to show the courts that that's not what the government is up to here. The government is taking away Butch's right to work and other people's right to work as a handout to their competitors.
Yeah. It's just mind-boggling that the idea of less supply would benefit and produce value there.
I know.
And not encourage not only competition but innovation.
Yeah,
and
innovation.
And let's be honest, the only way, in my view, to curb the cost of care, which is paramount to everybody, is to develop innovative consumption and delivery methodologies and technology.
Exactly.
It's the only way.
And, I think, some people's view of this is almost that, healthcare isn't really a free market, or, healthcare is just different than other markets. It's so important.
Oh, of course, yeah.
It's so important, so we've got to protect it. And the truth of the matter there is that if healthcare is so important, which obviously it is,
sure,
that's exactly where we need more competition, because competition is, just like you said, that is the fuel that drives innovation and, lowers prices and increases quality. I mean, if you're an entrepreneur, again, in a competitive market, you have got to be on your game to stay in town.
Sure.
And, the government has this arrogant view here that they know what's best for you and for me and every Mississippian.
Yep.
They know what we need. And
that's
the truth
exactly
is,
what this is.
It is. And they don't know what we need. There is no way they could know what we need. We know what we need.
It's central planning.
It is. It's total Soviet-style central planning. And what we need to do is not let politicians decide who wins and loses. We need to let individual consumers like you and I, by the choices we make, the businesses we frequent, where we decide to go, we tell through the market who needs to stay in business and who doesn't.
Totally agree.
And that will lead to better services, better quality, all of that.
Yeah, totally agree. So what's the next step? What's the next action in the case?
So now we basically, like I said, just got our ability, our right to have our day in court. And it's been a monumental effort just to get to that point. It's been a year-long battle just to find out that we are going to get to proceed in this lawsuit. And so now we'll have more of a chance to prove our case, because we'll have access to internal government documents to see what has the Department of Health been doing here, how have they regulated it, what have they found. We'll be able to bring in expert witnesses to testify in our case. Of course, the government will do the same, and so we'll have a lot of testimony that'll happen. We'll have a lot of exchange of documents where we'll get to, again, kind of dig into what has the government been up to, what do they know, when did they know it, that kind of thing. And at the end of all that, we'll either, depending on how it goes, we'll either get to have our day and have a trial where we prove to the judge, that this is not accomplishing what the government says it's accomplishing, or, we may even be able to, without a trial, have a situation where the judge can look at the evidence we've produced and decide that right there.
So, Aaron, I can't recall there ever being another suit such as this.
There is not in Mississippi, and now there's been some challenges around the nation in federal courts to certificate of need laws.
Okay.
None of them challenging a true health care certificate of need have succeeded ever.
Okay.
And now, truthfully, very few of them have made it past a motion to dismiss, like we just did.
All right.
And so, if we succeed here, it could be, assuming nobody else gets there first, it could be the very first federal case to ever strike down a health care certificate of need law in America,
wow,
which would provide a real toehold for litigators in other states to make the same case. Now, I'll tell you, the reason we brought this case is because while there has not been any success thus far, we feel like this is a really strong case to make the argument.
Okay.
And the judge agreed with us, because in this case, unlike every other, there's been a 40-year ban on home health agencies. That's never been litigated before. And you've got the government, putting arbitrary limits on very much needed home health care during a pandemic, when people really need care in their homes. And so for those two reasons, this really provides, in my mind, the best argument, the best case that has ever existed in America to say these certificate of need laws, particularly in this home health industry, are unconstitutional and arbitrary.
Yeah. You, of course, being a skilled attorney, I can just say from my business career, having dealt with so many attorneys across a variety of matters, the thing that they always seem to come down to as the common denominator is, does this pass the reasonableness test?
Yes,
right?
yeah.
This doesn't.
It doesn't.
40 years is unreasonable.
It doesn't. And I'll be honest with you, this case is even harder because the government doesn't even have to show it's reasonable. It just has to show it might be rational.
Okay.
And I'm just telling you, again, this kind of case presents all kind of challenges. And so the fact that we basically have a federal judge right now saying that, not basically, he has said that we have made a case here that meets the standard to say that this probably is not rational at all. And so,
unbelievable.
Yeah, so to get to that point is very good.
That's just unbelievable. Well, we appreciate your taking this case up. You always do a fine job with these thorny matters, shall we say. In this case, going after the government. And we'll be tracking it. Look forward to talking to you about it more. To you legislators out there listening, it's time we get rid of these combos.
It really is. It really is. Every branch of government should be looking at this. I mean, we're taking the fight to the courts. We're also talking to legislators through our policy arm.
Let's do it.
But yeah, it's time for this to go.
Appreciate it, Aaron. Talk soon.
Thanks so much, Gerard.
Man. Middays will be